sign-up sheet. If you're a patron and haven't signed, I grabbed the one that was on the table. So just continue to sign up as we go. So first up, Delegate Peter Farrell, House Bill 1513.
Hello, Mr. Chairman. How are you, sir?
Delegate, tell us the problem and how this bill fixes it.
Yes, sir, Mr. Chairman. Mr. Chairman, I'm presenting this bill on behalf of Louisa County, who made an official request. They are part of a regional jail, as I know many localities are, with the costs of maintaining those facilities and maintaining the prison population. The cost is rising, so they're looking for ways to ensure safety and save money. So what this bill does, Mr. Chairman, is it changes the code section about two-way communication. You had an existing statute about that if it was outside the jurisdiction of the court. What this bill does is strikes the condition that it has to be outside the jurisdiction of the court, and it strikes the word district as well. So if the locality makes the two-way radio or two-way video system available, then you'll use it, is what the bill says. And with that, Mr. Chairman, I'll leave. I'm happy to answer questions or hear thoughts from the committee.
Okay, so I'm reading it, and the first thing would be, let's see.
I know John Jones is here too, by the way, Mr. Chairman.
I'm not sure. Maybe I don't understand current law. Staff or somebody, can you? What current law for the jails, the regional jails that have multiple jurisdictions within. Oh, I'm sorry. Introduce yourself.
Mr. Chairman, I'm Steve Niedick, Counsel Courts of Justice Committee. Current law right now, if the committee would like to know, is that the courts are required, and it's actually just the district courts at this point, are required to use the two-way communication for anybody who is outside the jurisdiction of the court. And I think that's read as somebody who is not in their local jail. I can tell you most of the jurisdictions who use regional jails already use the video. In my reading of this, it seems that this is changing that to require all courts to use it at all times, basically, for these proceedings, bond, and attorney representation, because the word shall says that a court shall use the communication. If you strike the language from outside the jurisdiction of the court, you're requiring the courts to use them at all times, even if they have a jail, such as one of our local jurisdictions here that's attached.
Mr. Chairman, if I may, I take council's word. I think the county attorney for Louisa maybe thought that, took it very literally, that outside jurisdiction, they believe that because the local jails within their circuit and district court, that it counts as inside the jurisdiction, so they don't think they're actually allowed to do it. They may be wrong, and I'm happy to convey that message if the committee so chooses for that route to be taken.
Yeah, Mr. Chairman.
Delegate Klein.
I think I understand the problem the gentleman's trying to solve, and if he wants to try and, but I think he's creating some new ones. As the chairman just remarked, I don't think we knew that. I mean, some of us knew that shall was there, but I think we were shielded from it by it only applying to proceedings outside the jurisdiction of the court. So we rarely saw that as a problem arise. Now that you're allowing for interjurisdictional hearings to occur by video, the shall comes into play, and every one of them must occur by video if you have the video available. So creating a new problem.
Word, Mr. Chairman.
Well, I'm just happy to work with the patron if he wants to take it to the next meeting and try and solve the problem without opening it up.
Mr. Chairman, I'd be fine with that. I appreciate it and be fine with it.
Well, let's see, there might be, all right, anybody else have any questions for the patron? All right, I gather there's going to be they're going to try to do some work on this. Is there any member of the public that came to testify on this bill today? We'd be happy to hear your thoughts before a bunch of work gets done.
Mr. Chairman, I'm John Jones with the Sheriff's Association. We think it's a great bill. I've had sheriffs to tell me the regional jail will bring them in, sometimes 12 in a van, and overload the holding cells while they're holding court. This would be a great help. We didn't see what Delegate Klein brought up, and maybe we can fix that, but we hope we can get this done. Good bill.
Is there any reason why, if it said May, that'd be a problem? In other words,
are
the courts and the clerks and the judges hostile to this, or because?
Mr. Chairman.
I think it's the outside jurisdiction that becomes confusing for especially like Louisa, who's still in the circuit.
Mr. I say,
That would be
if you
fine.
make it may, then you've got the potential for a judge to require transportation from an outside jurisdiction for in-person proceeding. And I think council might have a solution
Okay.
that we could either do next time or take an extra 5 minutes and try and do it here.
I'd like to do it here.
All
We've
right,
got
that's
100, we've got
fine.
100 bills.
All right.
All right, so,
I think you have one more witness.
okay, yes, sir, if you would testify, tell us your thoughts.
Mr. Chairman, members of the committee, Don Caldwell speaking on behalf of the Virginia Association of Commonwealth Attorneys. We would support the bill with the change of the language from shall to may. We did not anticipate the other problem that was raised, but.
We'll talk to this guy.
Okay, so what we're gonna do is we're gonna form a special, did they go on job? You got it? Okay.
Mr. Chairman, what we would do is on line 21 before shall, you would insert a little a to break this into clauses, and then you would unstrike on line 22 the from outside the jurisdiction of the court language. And after that, on line 22, you would strike or B may use such communication in any other case.
Read the whole sentence.
Okay. As in, it would now read, if two-way electronic video and audio communication is available for use by a court for the conduct of a hearing to determine bail or determine representation by counsel, the court A shall use such communication in any such proceeding that would otherwise require the transportation of a person from outside the jurisdiction of the court, or B may use such communication in any such proceeding that would may use such communication in any such proceeding. Actually, no.
Well, Mr. Chairman, sorry, I can.
The language isn't there, but the concept is just you add the second section for may. So they.
I see, Mr. Chairman,
Yeah.
I think what council is trying to say is carve out the shall for the outside jurisdictions, then we just do a may if it's everybody else. Right. Yeah, and Mr. Chairman, if you'd like, I can, happy to work with Mr. Crowder now, or I'll take it by to your next meeting where we have a nice
No,
clean
we,
section before you.
if we get it done, we wanna get it done.
I'm ready.
Okay.
Yes, sir.
All right, so then the second thing the bill does is it adds circuit courts to the list by striking the word district. Not yet.
We did, no, we did not. Right, Mr. Chairman's right.
Okay, so that's a separate issue. Anybody have any questions for the patron? I don't care, but.
Mr. Chairman.
Delegate Klein.
I don't really see a problem with striking district. It makes it available for use by, what, JDR and circuit? No, JDR is considered a district court, so just be circuit. Being able to use video proceedings, not only shall use them from outside the jurisdiction, but then may use video for in jurisdiction proceedings. I don't have a problem with it.
Okay, so current law says circuit courts can't do it. We wanna clean that up here? I mean, you would have to have another sentence. Mr. Cotter?
Well, Mr. Chairman, just a question for the Commonwealth's attorneys. Don't circuit courts already do that in a lot of jurisdictions? I mean, in the ones I've worked in, they do it.
Yes.
It might be wise to include them in the law then. All right, Mr. Cotter? Mr. Cotter, we need you. So we wanna make it a may for circuit courts. Well, just keep what you're working on for the district courts, but a may for the circuit courts. Because right now, some of them are doing it and we're not sure under what authority. I think we got a big staff, lots of time. I'm just saying, can we create a special sub for the next 20 minutes and you guys get it done today? Okay, all right. Delegate Albo.
So when this bill was originally passed, I don't remember what year it was, the big controversy was, are you denying a person their ability to have a face-to-face appearance with a judge? And they didn't want to have defendants getting, I don't know if anybody remembers Max Headroom, but having a trial in front of a guy on a video screen. I did notice on the first line here it says that appearances before a judge can only be pre-trial. But are we concerned about, I mean, that would include motions to suppress and all pretrial motions, and do you want to have circuit court motion motions to suppress be able to be done by video. Line 20. Is available only for conduct. I'm not reading it the way you guys do.
Line 19, two-way electronic video and audio communication is available for use by a court for the conduct of a hearing to determine bail or determine representation by counsel. The court may/shall use such communication.
Well, it seems to me it's just deciding what communication can have for bail, but it doesn't exclude doing it for others. So that probably might be just a problem with existing law, that I'm making up a problem that we don't need to deal with.
I'm Eileen Smith with OES at the Supreme Court, and I think I agree with you, Delegate Alba. The first sentence seems to have no limit, that you may do it by two-way electronic video and audio communication. The sentence that is undergoing some change sets forth the situation when district courts have to do it by two-way, and that involves outside of jurisdiction. So at least in looking at the statute here, I think based on the first sentence, I think just for clarification, I'm not sure it limits circuit courts now. It just sets forth when the district courts have to do it by two-way.
That's why they can't.
Yeah.
So let's leave that alone, because all we're doing is messing it up. All right, so Mr. Cotter, we're going to form a special subcommittee headed by Delegate Klein. Anybody else who wants to participate, but we're just going to try to get the language right and come back, okay? All right, very good.
Thank you, Mr. Chairman.
All right, thank you, Delegate Farrell. All right, so, good start. All right, Scott here, I don't see him. All right, Delegate Lindsay, you have 1655. And also, while you're up, 1511.
Mr. Chairman, members of the committee, this is basically a transparency bill. Situation as it, for the benefit of Delegate Miller, this is not the bill that I was speaking to you about before. This bill has somewhat of a temperature brewing, but the situation now as it relates to the guidelines are recommendations for the members of the judiciary, and we requested them to give information as to why there is deviation, be it downward departure or upward deviation in the guidelines. Time and again, situations develop where judges don't note the reasons for their deviations, and then the situation is when asked, they just don't have basically an explanation, and that's a great concern for individuals who've been sentenced, and when the sentencing range far exceeds the scope of the guideline recommendations. This bill simply says that in instances where there is a situation where there's a deviation from the guidelines that exceed 12 months, and there has not been a recommendation noted by the governor, by the judges as to why they deviated, that is something that's reviewable on appeal if the court looks at it and determines that there's bias otherwise. And that's the change in the statute as it presently is composed, that if it exceeds the recommendation of the guidelines by more than 12 months, then in that instance there's a situation where it's reviewable on appeal.
I'm sorry, what's reviewable?
The sentencing.
The sentence itself?
Yeah.
Oh, okay, this is a very significant bill. Okay, anybody have any questions for the patron? Any member of the public like to be heard on this bill?
Yes.
Please come up, we'd be happy to hear from you. Ma'am, welcome. Tell us who you are and tell us your thoughts on this bill.
Okay. My name's Good afternoon. My name is Brenda Jefferson McLaurin, and I'm with RIHD, a nonprofit organization that helps prisoners, families, and their children. We support this bill that Delegate Lindsay is proposing for the provision F, because defendants in Virginia are getting trapped by harsh sentences and denied the right to a fair appeal. Judges have failed to follow the law. In this instance, we have current inmate now, Kevin Keys. Sentencing guidelines recommended 2 years, 2 days for incarceration. His actual sentence was 31 years. The judge failed to apply a written statement as required by sentencing guidelines in the provision B.
Ma'am,
I'm sorry.
can I ask you a question about that?
Sure.
Was that a jury recommendation?
No, it wasn't. Yes, it wasn't.
So there was
but the jury was not informed that parole had been abolished.
Okay, well, that might be a separate issue, but a jury recommended that he get 30,
Yes,
31
the reason
years.
why they did that is because they were not told that parole had been abolished.
Okay, thank you.
Okay. Okay. Just they failed to apply the sentence provision B that states that it shall be done. Because Virginia abolished parole, like I said, his release date now is 2027. 2027. Virginia law does not allow this form for the basis of post-conviction relief or to be reviewable on appeal under the sentencing guidelines under provision F. HB 1655 will provide that relief for unfair sentences, including Mr. Keys. We hope that you all will vote to return this injustice to the full committee for a fair and just resolution. Also, it is time to fix these mistakes. I read something once while preparing these notes, and it said if you want to make change in people, sometimes they'll start laughing at you. If you begin to initiate change, people will fight you. When people see results and change, they will join you. I'm asking that y'all join us and change these injustices and make it right. Thank you.
Ma'am, thank you. Delegate Alva has a question for ma'am. Thank you.
The situation you're getting is attorney advises client that these are guidelines, you should get 10 years based on guidelines, and then you go in and the judge just goes way off, and then you have no ability to appeal it because you got treated way outside the guidelines. Is that the kind of situation we're trying to address?
If I thought that was going to get the bill through, I might be tempted to say that, but that really is not it. This is really about transparency from a standpoint. I realize that the guidelines are suggestive or discretionary in nature in terms of they're being followed, but it's a situation where the whole reason that we requested that judges let us know why they are doing downward departures or why they're exceeding the guidelines is so that there can be public confidence in the fact that they're being universally accepted reasons for this change in the sentence or this deviation in the sentence. The situation when we don't have this reporting lends itself to the question as to whether or not there's fairness or bias, fairness versus bias in play. So that's to compel that if you exceed the guidelines and it's 6 months, 9 months, even 11 months, but once you exceed that 12-month period, then that's, in my opinion, where it should be reviewable.
Thank you.
Ms. Branscombe.
Joel Branscombe, Commonwealth Attorney, Botetourt County, here on behalf of the Virginia Association of Commonwealth Attorneys. We oppose the bill. It looks like what we're trying to get at is getting judges to fill out the paperwork. And what this bill does is if the judges don't fill out the paperwork, there's an appeal that investigates the judge's bias, which is a very hard term for us to deal with on appeal, what the bias is. It really just punishes the victim and the rest of the system for the judge not doing what they're supposed to do. So we were hoping we could find a
visualize a requirement that the judge explain the reasons. Some do from the bench, some don't. Has there ever been a requirement that a court order, the written order, contain an explanation of why?
Not the order, I think that when they put an upward or downward departure from the guidelines, there's supposed to be a written reason. Sometimes that will be a plea agreement or the severe injury to a victim, something like that, but they would put some reason why they're departing upwardly or downwardly.
Well, but that's reviewable. I mean, we use that for all sorts of purposes and rejiggering the guidelines and making sure that they're accurate, but in terms of literally saying the sentence can be overturned if the court didn't do it.
That's, as long as they're sentencing within the range of punishment.
Right.
It's not reviewable.
All right, thank you.
Mr. Chair,
Delegate Gilbert.
I move to lay this bill on the table.
Motion has been made and seconded to table the bill. Okay. All in favor of the motion table signify by saying aye. Aye. Opposed? Thank you, Delegate Lindsay. You have another?
I do, Mr. Chairman, and you were kind enough to invite me to address that one likewise. This is a
One 1511.
This is Bill HB 1511, and the situation as it presently stands is that there are certain laws that require a mandatory sentence that a judge cannot deviate or go beneath. And there are two categories in which there's mandatory sentences. Or two categories that I'm attempting to get at: firearm offenses. Right now, the requirement is that there is a pre-sentence report, even in a instance where the judge can only give that sentence. So you could have a situation where a prosecutor has come and made a plea agreement, still has to be a pre-sentence report, even though there's a mandatory sentence of 5 years for a felon who has committed a violent offense, or a situation where the situation where you're dealing with certain drug possessions and possessing a firearm. What this bill does is simply say that in these two instances, 18.2, 308.2, that it be modified, the statute be modified so that in those two instances alone where there's a mandatory 5 years and it's not a mandatory minimum and there is no deviation, that we could have a sentencing without the necessity of a pre-sentence report.
Okay, and are those the ones where the max and the min are the same? In other words,
Exactly. And those are the only two categories. Oh, and I apologize, Mr. Chairman, in my haste, I had Mr. Cutter to amend what was proposed, and I probably should have moved my amendment, but it's been passed out.
I'm sorry.
And
I'm sorry. Is there a sub or a line?
I was just so happy that you allowed me to do my second one after my first, Mr. Chairman. I
We'll
apologize.
think well of you at 5 p.m. when we're still here.
Mr. Chairman, on line 31, after 18.2-308.2, insert the language that is subject to a 5-year mandatory minimum sentence. And on line 31, later on that line, after the or, insert subsection C of before 18.2-308.4.
Okay. Delegate, are you checking? So, ask staff. So these are all where there's the mandatory minimum sentence is identical to the maximum sentence. There's really no there's a single sentence allowed under law.
Mr. Chairman, with the line amendments that were made, these are the three times that in the code it is a straight sentence of those years. It's possession of a firearm in the use of a felony. You have either a 3-year straight sentence or a 5-year straight sentence. And then in the case of 308.2, possession of a firearm by a violent felony of the straight 5 sentence. It's also a class 6 felony, so it can't go below or above the maximum. And in 308.4, the same thing. It is also a 5-year class 6 felony, but 5-year straight sentence.
Okay. All right. Anybody have any questions for the patron? Anybody have any questions for the patron? No, it's fine.
Okay. If there's a scenario where a judge may be looking to take something under advisement, would he still, in that case, he would not be able to have the benefit of a pre-sentence report, is that correct?
Well, the situation here is when the sentence is when the statute calls for the exact sentence that the judge can give, there's no need for the waste of a pre-sentence hearing. But if a judge were of a mind to take it under advisement, in the rare instances where that does apply in the statute, it does not apply in these instances. But that does not mean that they couldn't do it just as a matter of what they believe to be judicial discretion. This does not put any additional compulsion on a judge. It just simply says, why do a pre-sentence report if this is all we're talking about?
Mr. Chair.
Delegate Digger.
So what, I missed the beginning of it. What prompted you to submit this?
Because you've got a situation now where the offense that you're charged with can be a mandatory minimum that it cannot be below or.
I got that. What prompted you?
I had certain lawyers asking me to present it, given the fact that there was a requirement for pre-sentence hearing in an instance where there was already a agreement to plead guilty and no need for it.
So somebody figured out that it was just a waste of time and money.
Correct.
Okay. Just local attorneys in your jurisdiction, or like?
There were attorneys in my jurisdiction, yes.
But I mean, it brought you this.
Yes.
It wasn't a group or an advocacy group or anything like that?
No.
Just, okay.
Okay, anybody else have any questions for the patron? Anybody with the public?
Mr. Chairman, I have a quick question. I had this situation pop up about 2 months ago. Violent felon, possession of firearm. Jury found him guilty, gave him the mandatory 5 years. Judge sentenced him to 5 years, and I waived the pre-sentence report. We can still waive the requirement of pre-sentence report, or are we dealing with an issue where judges are ordering pre-sentence report even upon waiver?
I'm not sure that there could be a waiver of the pre-sentence report. As I read the statute, there's a requirement for the pre-sentence report, and this avoids that necessity.
Thank you.
All right. Anybody else have any comment? All right, Doug Lindsay, one of the issues here is we're not sure we're smart enough to think of every scenario. I can't think of a reason why it wouldn't be enough to just say they can choose not to have it rather than specifically saying they cannot have it. I don't have the wording in my head, but any reason why we couldn't just say that it can be waived or passed or something for these?
I don't see a reason for that, you know, and I'm not averse to that.
It saves us from the thing that none of us have thought of, or the judge really wants it for some reason, and it's important, and in fact it doesn't. Do we have one of those? Okay, we are being told there's another bill coming through that is on the same turf. We try not to take them up in separate hearings, so I think.
I move that this go by for the day.
Okay, so we've heard you. This will come up again. You're welcome to come again when it comes up next. We've got 2 bills apparently on the same topic that I did not know about. So,
very good. Can you tell me who the other patron is so that I can converse with he or she?
It is today. Okay. There is another one coming up. It's just separated by the hour. So if you're still in the building, we'll just call you down.
Good enough.
It's Luke Hossie has one.
Thank you.
Thank you, Delegate. Thank you.
Move
All
this
right.
go by temporarily.
Yeah, down by temporarily. Hearing no objection. All right, we have Robinson and then Ware and then Cole. You're in the next block, but we'll take you up and then Farrell will work you in if you're ready. Okay. Roxanne, go ahead. Delegate Robinson, welcome.
Thank you, Mr. Chairman, members of the committee. House Bill 1921 is really on line 52, 53, 58, 59, and then the second enactment clause. What the bill does is it's ensure that our healthcare professionals who are physically insulted in the hospitals are protected in the same law where they are emergency room, waiting room, or any area of the hospital. When this bill first came, was brought to my attention, I was visited with some nurses who live in my district who actually wanted this to be a felony, and after conversations with with legislative services, Delegate Alba. We figured that that probably wasn't our best avenue of approach. And so Senator Sturdivant, Senator Donovan, Andrew Lamar, we kind of all put our heads together and came up with this as an alternative to that, and to protect all the hospital workers, no matter where they are in the hospital, not just emergency room personnel. And then also to, the second enactment clause is just to direct the Department of Health to convene stakeholders to develop a model policy for violence prevention programs to prevent assaults in the first place, as well as for deterring violence by making the public aware that they could be subjected to an elevated penalty for physically assaulting a health professional in the hospital. And that sums up pretty much
Alright.
what the bill does.
Any questions for the patron? All right, anyone in the audience wishing to speak in favor of the bill?
Thank you, Mr. Chairman. Andrew Lamar on behalf of the Virginia Nurses Association. Thank you to the patron for carrying this bill. As she explained, we're not asking you to create a separate class or an increased penalty. We're simply asking that the health professionals that are working in Virginia's hospitals be treated the same if they're physically assaulted, whether they're in the ER or another area of the hospital. We worked with other stakeholders who are supportive, including nurse practitioners, midwives, the Virginia Hospital and Healthcare Association, who are also here to speak in favor of the bill. So would appreciate your consideration.
Thank you. Yes, sir.
Mr. Chairman, members of the committee, I'm Brent Rawlings with Virginia Hospital and Healthcare Association. We support this bill focused on workplace violence as a primary concern of ours, and we have seen multiple reports, incidents of violent assaults within our hospitals that would not currently fall under this statute because of the way that it's crafted today. So we encourage you to support this bill. Thank you.
Thank you. Yes, ma'am.
Hi, I'm Chelsea Savage with the Virginia Nurses Association. I also have many years of risk management across the street at MCV Health, BCU Health System. We are on the front line of assaults and batteries against our health providers basically every week, and it does extend well throughout the hospital, past the emergency room, and in our outpatients and our clinics. And so I really hope you guys support this bill. Thank you.
Thank you. Anyone else wishing to speak in favor of the bill?
Thank you, Mr. Chairman, members of the subcommittee. I'm Melissa Gibson. I'm with the Disability Law Center of Virginia. We don't want to speak in opposition to the bill, but we do want to, when making recommendations to the Board of Health, consider that often individuals who might be impacted with this are mental health consumers who are in crisis, and we'd just like that to be taken into consideration. Thank you.
Thank you. Anyone else wishing to speak on the bill? All right, discussion from the subcommittee.
Mr. Chairman,
Delegate Allen.
this doesn't get my speech because, in my opinion, they're not adding to a special class of people. In other words, they're not adding to the list of special people. And you'll hear my special people speech some other day. They're just saying that having it only apply to emergency room doesn't make any sense, and it should apply to the entire hospital. So the ALBA rule is not invoked in this.
All right. Delegate Gilbert.
Move to report.
Quick.
Okay. There's a motion to report. Will the delegate withdraw?
Yeah.
Thank you. All right, Delegate Wise.
Thank you. Just wanted to make sure on lines 58 or 59, what picks up clinics that we are dropping in our generic language? What, you are picking up clinics?
Yes. Yes.
You,
In the, it's in line 53, the premises are of any clinic or facility rendering medical care.
just reword. Thank you, sorry for this.
Council.
Just want to make sure the committee is aware that in my reading of this bill, we're adding to the area in which hospitals where it can occur. We're taking it out of just the emergency room, but we are putting in there at a clinic that it can only occur in the emergency room. If that's the intent of the patron, then that's what it is. I just want to make sure the committee is aware of that.
I too am rewording, and so I was half listening. So right now we have a hospital or clinic. That's it, and then it says or in an emergency room. So if we take clinic out of that generic, are we still able to pick it up when it's not emergency? There's all kinds of outpatient clinics out there.
Mr. Chairman, as I read it, the bill right now reads it as this only applies in an emergency room in a clinic, but it applies in the entirety of a hospital.
Mr. Chairman, so I don't know that it applies in the emergency room of a clinic. It applies in any clinic that renders emergency medical care. Right? So I think if there is a room dedicated to emergency situations in a clinic, which I don't know how that works, but does not, the way that is written, apply to the entire clinic if the clinic renders emergency medical care.
Mr. Chairman,
Yes. In other words, not just the room where the emergency room.
but the requisite condition will be that the clinic somewhere in the clinic emergency medical care is provided.
Okay.
So if you have a clinic where emergency medical care is not being provided, they would not be covered under this.
Where is a clinic that rendered, like, are we talking about like a urgent care, or what are we talking about with a clinic that are?
Mr. Chairman, when
like
we were looking at this language,
pre-clinic?
we were thinking of a freestanding emergency department that would exist that is not in a hospital, so to speak. So, which is different than an urgent care clinic like a patient first, for example, is not an emergency render.
So there are
rendering
places,
emergency services, urgent services.
So there are places like a
freestanding Mr. Chairman, a freestanding.
I don't know about this entity that. Go ahead.
A freestanding emergency department is part of a hospital, but it's not physically located within the hospital.
I see.
Mr. Chairman?
Yes, Delegate.
I'm looking through the code right now, and I'm not aware if there's a definition for clinic anywhere in the code as of right now. Is that correct?
I'm not sure.
Mr. Chairman, I can tell you there's no definition for an emergency room anywhere in the clinic. And I looked at that based on the fact that of the first, I don't believe there is a definition for clinic either.
Would that mean at this point that, a student center, for example, at a hospital where there are medical services that are provided, would the entire student center then be an actual place for this?
I think that's the question. Then I think we need an elbow speech. All year long. Clear.
Mr. Chairman, I'll just clarify our intent.
I think it's fine. I think it's fine.
Mr. Chair, Mr. Chair, I move to report.
All right. So motion to report, is there a second? Motion second, recommend reporting. Any further discussion? All in favor say aye.
Aye.
Opposed? All right, thank you. Delegate Bell.
Members of the
Thank
committee,
you.
there's some scheduling issues. Let's just move them. So, I was informed by Delegate Freitas that he wished not to have 1896 heard. I was informed by Delegate Philicorn that she did not wish to have House Bill 1706 heard. There may be more, but those are the ones that I'm aware of today. And so the practice in the past has been to put those on the calendar for the last day that we have a regularly scheduled meeting. Mr. Cotter, what day is that? The late night for Crim Sub is
most likely the Wednesday of February 1st.
okay. So I'll entertain a motion to move both of those to the docket of the 1st. Is there a second? All in favor signify by saying aye. Aye. Opposed? Okay. We have Delegate Ware, Delegate Cole, and Farrell, then Pogge.
Given the moniker of the event that you just alluded to, perhaps appropriate that House Bill 1432 is before you, which has to do with knife laws in Virginia.
Delegate Ware, wait one sec. We don't have to move it, but if you're here for House Bill 1398, that patron is, we're also moving that one to another date. So if that's the only reason you're here, you can go. All right, Delegate Ware.
Thank you, Mr. Chairman, members. House Bill 1432 comes to you because of a conversation I had with a constituent about his hobby, which is knives. And he is a member of a club in Richmond, the Richmond Knife Club, that meets regularly. And out of that arose his concern that the current law in Virginia is at least ambiguous, or because adopted at various times through the years has become less clear than it might be. And so from that comes the bill that is before you, and I'm going to explain why we think that it ought to move in this direction, and I'm going to give you some of that background. There are a number of Virginians who, either because of their hobby or because of their work, will carry an automatic knife as a tool. And so there are a couple of sections of the code that would be, I think, enhanced if we could clarify them in the way that are provided in this legislation. The Commonwealth prohibits possession of knives, which leaves law-abiding and well-intentioned Virginians who do carry a knife for everyday work and activities, people like tradesmen, hunters, campers, at risk of arrest simply by possessing a knife that is legal to own. And in Virginia Code section 18.2-308, and here I quote directly from that, any person who carries about his person, hidden from common observation, any dirk, bowie knife, switchblade knife, ballistic knife, machete, razor, and so forth, is, and there I end my quote, is violating the law and subject to either a misdemeanor or felony, depending on violation specifics. And to further complicate things, there have been different readings in Virginia courts as to whether a dirk knife or switchblade knife includes all fixed blade or locking blade knives. So first is the prohibition on possession. Second part is that Virginia law appears to define possession as the intent to sell. And I draw your attention to Code Section 18.2-311, which states that a person carrying, quote, and here I'm citing the code section, switchblade knife, ballistic knife, or like weapon, and having in one's possession any such weapon, shall be prima facie evidence of his intent to sell, barter, or furnish, end quote. Since an automatic knife, referred to frequently, and in these two instances as a switchblade, is not defined as a dangerous weapon, it is legal to own. However, the contradiction of these two sections seems to indicate that a person openly carrying an automatic knife could be in violation of either section. As to point one example, a roofer may carry an automatic knife in his pocket as part of his customary tools of labor. While perched on a ladder, he has one hand to open the blade and use it. When he finishes for the day, he slips his knife into his pocket with his belt clip visible. Though the roofer is not carrying the knife as a weapon, but merely as a workman's tool, and certainly doesn't intend to sell it, he could be found in violation of the code section 18.2308 and 18.2311. That ambiguity is what gave rise to my constituents' concern and the reason why this bill is before you. I know he speaks for a number of people who share his concern, and there are a number of folks who use it as a tool who have also indicated their support. That is why the American Knife and Tool Institute is supporting this, and I do have Savannah Kelleher with me, who is from the Institute, who could also answer some of these questions. I want to note one thing specifically in addition to what is on the legislation, and that is we have made use in this of the frequent term from the Virginia Code, which is switchblade. I think there's an advantage to using the more generic term automatic knife, and that would be in lines 6, 16, and 18, but that's, you all are the ones who know the code and know what the options are in that regard. So, Mr. Chairman, members, that's the gist of where the bill comes from and why we think this would be a salutary change.
Okay. I have some questions about existing law, probably directed to staff, not to you. So,
okay.
The list of knives that can be concealed include dirks and Bowie knives, but not all knives. And there's a case on it. It's been a long time since I've read it. Could you remind us what is a concealable knife under current law?
Mr. Chairman, I was just pulling up the case from the Court of Appeals that basically the knives that are illegal under those statutes are really have to do with what their use is and not necessarily what they actually are. There have been court cases where kitchen knives have been found to be concealed weapons, and court cases again where they're not, because the court will look at what the surrounding circumstances of the case is. And look at the circumstances of whether or not the knife actually had a purpose to be used in a legal manner. But that really goes under the language in 308, which is of like kind to those enumerated. I believe that the case law is pretty clear that if it's one of the enumerated knives, it is just cannot be concealed.
And there's nothing wrong with owning them, those other knives, you just can't conceal them.
That's the prohibition, although the Delegate Ware points out that under 182311.
No, I'm going to get to that, but just in terms of the dirks and Bowie knives.
That's correct. It's
okay.
just concealing it. That's a problem, not necessarily the ownership of it.
Okay, and then with a switchblade or spring-loaded knife, there's a separate code section about the ownership itself that makes it illegal. That's the 311 section.
That's correct. That makes that a class 4 misdemeanor. It says to sell. It is not necessarily. It's one of those statutes that criminalizes the sale of those, but also says if you have even one, we're going to assume that you're going to sell it.
Okay.
And so it does criminalize the possession, basically, but it is a class 4 misdemeanor.
Would a spring-loaded knife qualify as a dirk or Bowie knife if it were concealed? In other words,
I don't believe so. I believe it. Switchblade.
Either.
Switchblade knife. I think it's. If it's one of the, it wouldn't need to qualify as a dirk Bowie knife because they're both specifically enumerated in the statute. When we're talking about like knives, that's what we talk about. So when we're talking about knives that aren't specifically enumerated in the statute, but can be used in a way such as that kitchen knife, which is the Ricks case, that's when we start looking at what their purpose is. But if they're enumerated, we don't need to compare them to dirk Bowie knives because they're specifically enumerated. So switchblade knife, ballistic knife, spring stick, any of those things are specifically enumerated in the statute.
Okay. All right. Anybody else have any questions for the patron?
I do.
Delegate Gilbert. And then.
So what would be, again, I've been trying to figure this out while we were doing this, so I don't, at the risk of making you repeat yourself, I apologize. That's quite all right. What would be the type of, I mean, I can see various recreational activities that would involve the use of a knife, right? Specifically, where have folks found that a knife of that type would be most beneficial to them or safest for their use in a recreational activity? This gentleman who brought it this to me originally expressed the concern, given the current state of the code, that when he and his fellow club members of the Richmond Knife Club attend meetings, they are concerned that simply driving to and from their club, where they sort of, I suppose, talk about the virtues of various kinds, and he has a fairly substantial collection, variety of them. He was concerned that he might become, could be charged. So now my concern is, what the problem you just expressed is not something that the bill solves, to the best of my knowledge. So in your lawful profession or recreational activity, to me means like you're being a roofer, or you're out sailing, trying to, you have to cut a rope or something. Right. Not driving to a meeting. So the bill seems to limit it to working or recreational purposes.
And the term recreational activity
is undefined.
And the Sheriff's Association had pointed to that as something that's probably overbroad. If there is a more artful way of getting to that concern.
Well, the more artful way is just to say you can carry it as long as you're,
law
legal otherwise, right? I mean, unless it violates the law some other way, which I don't know what that would be necessarily, but.
That's the.
Sure, but that's already the problem. I mean,
Well, this would take it, this would.
no, this allows you to carry it concealed.
Right. Right. Anybody else have any questions for the patron? All right. Any member of the public like to be heard?
Mr. Chairman, ladies and gentlemen, Bob Sadler, Virginia Citizens Defense League. Philip sends his regrets. He's tied up in a board meeting, particularly to Delegate Ware, being a constituent. VCDL strongly supports this bill. Anything that expands self-defense options, particularly running to less lethal than handguns, is not only mandated by state case law in Diffendahl v. Commonwealth, it is also constitutionally protected under Supreme Court law in Catano versus Massachusetts. We support the bill, and we hope it is your pleasure to pass it. Now, aside from my position in VCDL, I speak to you as a commercial electrician, a residential HVAC installer, both a residential and commercial maintenance man. I could not begin to count the number of times that I have been slithering through a crawl space or wriggling around in an attic. I barely have room to reach my belt, much less to open a knife. Or for that matter, I'm holding something up over my head, and I have to reach for my knife and do this thing here. These knives were originally designed as tools for the tradesman. Use as weapons was incidental. This would make my job and every other tradesman I know a lot easier. Please, please make our jobs easier. Pass this bill. Thank you.
Mr. Chairman, I just want to make sure you and your members understand that this bill has nothing to do with self-defense and would not accomplish that in the least by the way it's worded.
Correct. I was told to provide support for the bill.
I understand, but I just want to make sure why you're supporting it is clear to the people you represent. I mean, so the tradesman stuff is clearly contemplated by the wording of the bill. The rest of it is not at all. Like, it would not solve that at all.
Actually, Mr. Gilbert, you'll be hearing a lot more about less lethal weapons after crossover, but that's a whole.
Okay, I think you know where a bunch of us stand on the issue you put forth at the beginning of your comments. It's just that I don't think that this accomplishes that. So that's all I was saying.
I have orders to support the bill.
Okay, thank you.
Mr. Chairman, if I may just make a comment about that. I'm not sure that would in any way prohibit it. I guess if someone were faced with a situation and they had a tool on them that was allowed by the statute as amended by this bill, I suppose it could benefit that objective as well, even though it's not crafted for that purpose. I would just add that.
Yes, sir. Mr. Jones, go ahead.
Mr. Chairman, I'm John Jones, representing the sheriffs. The sheriffs had, while some of the sheriffs didn't mind the bill, some brought up the issue of the overbroad language, talking about recreation. So if you're going to allow switchblades and you're talking about it in recreational settings, you're pretty much opening it up for anything. You can be walking down the street at 2 a.m. and that's your recreation. So just consider that. Some of the sheriffs have an issue with that part of it. If you want to open it up for trade issues, we're a little bit better off with that, but recreation, a little bit too broad for us.
Mr. Chairman,
Delegate Watts.
I was prepared even before that to move that we strike the words "or recreational activity" that begin at the end of line 17 onto line 18.
Second.
Delegate Miller? Oh, I'm sorry.
That's all right.
Yes, ma'am.
Okay, I had moved with, it was duly seconded, that beginning at the end of line 17, strike the words "or recreational activity" onto line 18, so that it covers the tradesman use, but not the undefined recreational activity.
Okay, was there a second?
Second.
Okay, the motion's been properly made and seconded. Do we want to have any debate on this? Okay. All in favor signify by saying aye. Aye. Opposed? Oh, better count. Okay. The motion was to strike the words "or recreational activity." All in favor signify by saying aye. I'm sorry, we did this. Noes, raise your hand. 1, 2, 3, 4, 5. Okay, noes carried. Okay. Question for the patron. Okay, so, I don't see anything especially wicked about the knife, but I also don't see how they're different than all the other knives we currently have covered by the concealed carry statute. In other words, you can have it. Okay, all right. And so I guess what I under the second, the 311 would allow you to have these knives just like any other knife. There's no longer plutonium, the knife. But the previous provision would make them better if you elevate them past what other knives could be. In other words, you would say that as long as for these purposes you can't have it concealed. And it seems like it should either cover lots more knives than this. You're creating a special category for these knives. Is there a reason why?
Because of their use for trades, and that's why the broader term automatic knife, I think, would be better than switchblade, which is a subcategory. As I understand, I cannot profess to be a specialist on the definition of a dirk or a bowie or distinguishing those. But the way it has been related to me by people who do know more about it suggests that would be a better category to include. Is that responsive to your question, Chairman?
Yeah, I guess. I'm just trying to, we're creating what I see as an unusual little carve out. If it's a good one, we should include more in it, or if there's a problem, perhaps. Okay. It's not. Gentleman has his own bill, so.
Move to report.
All right, motion made to report the bill. Is there a second? Okay. All in favor of reporting the bill? It was not amended, so the bill as introduced, signify by saying aye. Aye. Opposed?
No.
Okay, noes, raise your hand. Thank you. Thank you, Delegate Ware.
Thank you, Mr. Chairman, members.
All right. We had Cole and Pogge, and then I understand, Farrell, we're good to go? I think, okay. I hope so, Mr. Chairman. All right. Delegate Cole.
Thank you. I have House Bill 1404. House Bill 1404 was brought to my attention by a fire captain who lives in Spotsylvania but works in Fairfax, I believe. Anyways, my understanding is that someone set off a fire alarm at an apartment building, and they cited him for maliciously activating a fire alarm. However, the way the code is written, it's only illegal to maliciously activate a fire alarm in a building that is used for a public gathering or a public assembly. And the judge ruled that an apartment building was not a public building and not for public assembly, and therefore there was no law against maliciously activating a fire alarm in an apartment building. And so this would just simply strike the requirement that the building be used for public assembly and make it illegal to maliciously activate a fire alarm in any building.
This would cover my home's fire alarm? I'm just thinking out loud.
Yeah, it probably would, I suppose. Maliciously activating it. That means you are intentionally, you know there's no fire, and you are intentionally activating the fire alarm.
Anybody have any questions for the patron? Doug, I'm sorry, we were doing two things up here at once. I'm sorry, Doug, no.
Why the teenage kid fire alarm would be sustained?
Yeah, if the fire department has to respond to the call, they could be charged under that. Again, it's a misdemeanor offense.
The law actually says regardless of whether they respond or not.
Yeah. Yeah, but usually, if there's no response,
Nobody's gonna get worked up.
nobody's going to issue a citation.
Mr. Chairman,
Delegate Watts.
did you consider on line 16 of at least saying in any public building? Rather than just any building, because certainly all the language that goes after that, and notice there's no hotels or anything else in there, which is a weakness of the current language, but they're all public, and you're really changing it.
Yeah, this was what was requested by the fire captain, in that an apartment building is not a public building. It's a private building with private residences in it. And the way the law is right now, it's not illegal for me to go into an apartment building, pull the fire alarm, make everybody evacuate the building, have the fire company respond. I can say, yeah, I pulled the fire alarm. I know there's no fire, I just wanted to do it. And that's not illegal.
Could I just pursue one moment? So the definition, the definition that the fire chiefs are giving you, is that somewhere in
It's
code?
right there in the current code. Used for public assembly or for public use or other public use. An apartment building is not for public assembly or public use.
Even though it has a lobby that is open to the public?
That's not for public assembly. And this is based on a current, a recent court ruling. That, like my understanding is someone did just what I said. They activated a fire alarm in an apartment building, and they were cited for maliciously activating the fire alarm. And when it went to court, the case was dismissed because that's not illegal.
I have a question for counsel. So we're putting an awful lot of weight on the word malicious. In this context, give us some examples of the most malicious and least malicious you could be and still qualify under the criminal definition for malicious.
Yeah, the least malicious one is easy. I think the committee's been talking about it as we've gone, is that a child or teenager wants to have some fun and pushes the fire button on an ADT thing in your home and knows that it's gonna, knows that there's no fire, knows that there's going to be a response from the fire department, yet does it anyway, and that would be malicious. That would be with a bad purpose, which is really what the definition of malicious is. And I think, as the Delegate Cole has pointed out, the worst one, which is this large public building, and the reason that this is a statute in the first place is, I think schools, is they don't want the students pulling the fire alarms at schools in order to attempt to make people in a stampede or in just in an orderly fashion have to evacuate a building. Becomes a nuisance to both the fire department. It's the same reason we have falsely summoning law enforcement officers. It becomes a nuisance and it costs money to the fire department. And so, I think
you keep talking about when there's a response, but it would just somebody wants to wake me up in the morning. They hit just the one in my house. It doesn't go any. It just makes a very loud beeping noise.
I mean, I would have no objection if you wanted to exempt, single-family home private residences. The main target here, as I said, was a case, I believe in Fairfax last year or year before, where somebody activated a fire alarm, knowingly and willfully activated a fire alarm when there was no fire, and was charged with maliciously activating a fire alarm, and the judge ruled that it was not illegal for him to do so in an apartment building.
Mr. Chairman.
And the same would be with an office building too.
Or a dormitory for that matter.
Yeah. And I would point out that malicious is in current code. It's not something that I added to the code.
All right, we have much bigger bills than this awaiting our attention. I can't think of a way to get office buildings and dorms and apartments that don't also get houses, but I think we ought to get office buildings, apartments, and dorm rooms. So I will move to report.
Second.
All in favor signify by saying aye.
Aye.
Opposed? Okay. Thank you. Hoagie, Farrell,
Thank you, Mr. Chair. House Bill 1874 is actually a follow-up to a bill that we passed a couple years ago. It's a housekeeping bill that when a video magistrate is used for a search warrant, they could be anywhere in the state. Current law requires a deputy who serves a search warrant for bank records in any locality, York County, for example, to file it in the locality where it was issued. If the video magistrate was located in Fairfax or elsewhere, the deputy would have to go to Fairfax to file it. This allows the deputy to file the search warrant where it was served. It's a great time and effort saver, and was brought to me by the Sheriff's Association.
Council. There's somebody that does these a lot. It's not me. Could you sort of walk us through? There's a lot of words in a fairly technical part of the code.
I see this bill as actually doing two separate things, Mr. Chairman. The first thing is, as the delegate talked about, was this eliminates the requirement that the search warrant be filed where it is issued. That's the first thing. That's one separate that applies to really looks like any search warrant, not just the search warrant that we move down to what the second thing is, which is the new language from 93 to 105, which talks about search warrants for electronic or financial documents, which allows a officer to serve by mail, commercial delivery, fax, or other electronic means upon the financial institution. I'll tell the chairman from my experience that is typically how it is done now anyway. Most of these places have, for personal service, they have, and there's one down a few blocks from here at the Bank of America building that basically accepts service for any major national corporation, and then they fax the actual warrant to the legal department at the company. So that really is probably just a codification of existing practice. The other issue is really just where do we want it filed, and I practice in an area where the magistrates are all close to the where that is, so that it's not such an inconvenience. I can't think of a time where a York County deputy would want to ask a magistrate from Fairfax unless the magistrate from Fairfax is sitting for the York County magistrate. Because if you have an investigation in York County, they can get even if the company is in Fairfax County, they can get a warrant from York County where it's issued and then serve it upon the people in Fairfax, or have the Fairfax County Police serve it. And so you would just have to, in that case, file a return actually in both places based on where it's issued and where it is served, because, and another issue in the 93 through 105 language talks about that the warrant in the instance of a financial institution must be only filed where it was served, and I do have some issues with that language. I can bring that up now, or we can take that later.
Well, let's organize our thoughts so that Delegate Pogge, the lines 25 and 26 says that the affidavit goes back. Do I have it right? I'm looking at council. Lines 25, 26, the affidavit, in addition to wherever else you file, has to be filed back in the court where it was issued. Is that the?
That's correct. That's existing law.
What I understand is this would take that out.
Yes, that's the
why? What is that? No, I'm asking the patron. Why is that a good idea? Why would we do that?
You're asking me why?
Yes, ma'am.
Well, this is the bill as it was brought to me by the Sheriff's Association. I do know that a couple years ago the process was amended so that a search warrant could be issued anywhere in the state, not just the jurisdiction where it was to be served. That they are maintaining that this is a housekeeping companion that follows the same line of thinking by streamlining the process. I know there's a companion bill in the Senate carried by Senator Norman.
Ms. Jones, if you want to. So I've got. Oh, so that you can find it, right? So I'm a defendant in Albemarle County, and I don't know if I'm in trouble or not. So every so often I go down and I check the search warrants. Is that sort of the mechanism? I don't do this. Okay. But if we don't do this, that search warrant could be in Fairfax or Virginia Beach or something. Why? This doesn't seem like that big a deal.
I think Mr. Chairman, I think the key is, excuse me, the video, when the video is used. So the deputy doesn't have to go wherever the magistrate appeared on the video. The magistrate on the video may be remote, and you don't need to file it there. You need to file it where the action is taking place in the locality where the deputy is or where the sheriff is. That's what I understand the issue is.
No, I'm just asking lines 25, 26, where it says, and you got to send a copy back to the place it was issued. I'm having a hard time seeing why that's such a.
I don't think you need.
Mr. Chairman, I'm Mason Bird, Director of the Magistrate Services Division at OES. This language actually preceded the statute that gave us statewide authority. It's always been there. It's been confusing for many of our stakeholders. So we'll go back to your example up in the 16th District. Orange County Magistrate sits in Orange County and is available roughly 24 hours a day. Louisa County, someone's not always in Louisa. A deputy might drive to Orange County to get a search warrant to be executed in Louisa. We have to file the affidavit in Louisa where the search is going to be made. We also have to file a copy in the Orange County Circuit Court. The problem with that right now is nobody knows that. That's not on the affidavit. It's not on the warrant that we filed a copy in Orange County. And one problem for that is let's say later a CA gets a sealing order, he doesn't know that he also has to deliver a copy of that to the Orange County Circuit Court. So it has created some issues with stakeholders such as CAs in that type of circumstance.
Mr. Chairman. Okay. Delegate Watts.
So what I'm hearing is that the problem is they don't know they're supposed to do this. What I didn't hear in your explanation that there was a problem with the way I read the law, which says you've got 7 days to get that copy to where it was issued, and it can be done electronically by fax, certified mail, etc., so that that record exists in the where it was issued, so that somebody can go find it who may be related to the case.
So well, let's give the same example. It's a Louisa County case. Louisa County Sheriff's Deputy goes and investigates the case, finds that there's evidence in Louisa County, and he wants to get a search warrant. The defendant is going to be tried in Louisa County. Everything's Louisa County, except the Louisa deputy drove to Orange, where the only magistrate is. He issued that search warrant. The magistrate files the affidavit, the original, in Louisa County, so the deputy, the CA, the defendant, everybody knows that there's a copy in Louisa County. Very few people know, except the deputy, that he drove to Orange to get that. Orange is a repository of lots and lots of search warrant affidavits that have nothing to do with Orange cases. There's no case prosecuted there. It's only that the magistrate was sitting in Orange, and that's the reason why Orange is a big repository of these. It's a problem for the Louisa CA or some other CA in these type of cases, where later on he files, or he gets to the circuit court to give a sealing order. He says, hey, let's take this down to the Louisa Circuit Court and make sure nobody can get the information that's confidential in the affidavit.
Let's take it out of Louisa and Orange.
Yeah.
Let's say
Fairfax and Alexandria right next to each other.
Shenandoah. So, Sheriff in Shenandoah is investigating one of Delegate Gilbert's clients. And the client says, could you go down and check to see if there's any search warrants? The warrant is for a bank record here in Richmond, so we do what we're talking about.
And I'll just say, there are two separate issues in this bill. We're just dealing with lines, the top lines.
Yeah, no, right. No, that's
right.
We're going to go through them all. So Gilbert's a good lawyer. He wants to look. Of course, he wouldn't want to search every circuit court in the state. He goes to Shenandoah because that's where the guy is. That's who the sheriff is. Is it that hard to file it back in Shenandoah, even though it's being served in Richmond? Or?
Well, currently, there's nothing that requires anything being filed in Shenandoah. If the magistrate wasn't sitting in Shenandoah, and so he didn't issue it there, and the search is conducted in some other jurisdiction, nothing is going to be in Shenandoah. We actually have that happen from time to time as well.
If the sheriff goes to the usual magistrate, which is this Shenandoah magistrate, gets the search warrant for the bank records, after some looking around, the deputies discover that it's these ones we're talking about, which is the Richmond, wherever the service is. He serves it. It was created in Shenandoah. He serves it in Richmond. Current law would require them to file that back in Shenandoah, right?
Correct. A copy would be in Shenandoah.
Okay.
That's assuming that the magistrate was in Shenandoah. We have a variety of counties.
Okay.
You know, Louisa, Fluvanna.
Well, I understand.
They're very rarely there.
I guess I'm really struggling with why this. I could see that we wanted to track back. That's where it was got. I'm not seeing much of a reason to change this. I understand the second part is a bigger deal, but this doesn't seem to have anything to do with it.
Correct. The concerns that I've heard from our stakeholders about the copy being filed where it was issued are primarily from the Commonwealth attorneys, that when they're doing a sealing order, they don't know that a copy was filed because they don't know where the magistrate was sitting. It's not on the search warrant where a magistrate was sitting when he issued it. Now, as the patron states, especially with statewide authority to issue one, it's very difficult to determine where to send a sealing order for that copy. The original will be where it was executed, where the search occurred. It has always been a problem. The statute has never directed that where a case is to be prosecuted, a copy will be. It's always been where it's issued. There perhaps was at some point a belief that where it was issued is where the case is going to be prosecuted. That's not necessarily the case.
Delegate Klein.
I was going to say, wouldn't a better solution be to note on the warrant where the magistrate is located? so that you then know.
Well, that
where
would
to
solve
find-
the ceiling order. There's still a variety of circuits where, in Orange County, where Delegate Bella's from, Orange County Circuit Court has a lot of search warrant affidavits that really have nothing to do with Orange County cases. There's nothing prosecuted there. The search didn't occur there. It just happens to be where the magistrate sits. That would be a good clue for some people to go look where the hubs are for magistrates.
Does somebody, I'm not, again, way out of my usual practice area, that the paragraph, counsel, if you could walk us through sort of line by line what this does, it's a lot of words. Two.
Mr. Chairman, we're talking about lines 93 through 105.
Yes, sir.
This allows the service of search warrants that are issued to financial institutions be done not only by hand, which is what I think the existing law is right now, but could be done by mail, FedEx, fax, or other electronic means upon the financial institution. And it also requires, and this is, sort of tracks with the other, this sort of talks about what we were talking about with where to find the statute in the example you were giving with Delegate Gilbert. It defines that the search warrant only must be filed, I want to make sure I have the language right, where it was executed, so that you don't have the double filing requirement that would be on every other search warrant. So that's the change that these.
How do you execute it if you're doing it electronically?
That is a concern that I had when reading the statute, that where is something that is emailed or faxed, where is that executed? If I am a police officer and I email a search warrant to a person who is in Charlotte, North Carolina for SunTrust, am I executing the warrant in Charlotte, or am I executing the warrant at my desk in Richmond City? And I think that's an issue that I was going to bring up.
Well, if we make this change, it has to be filed where it is executed?
That is what the language says.
But it eliminates the requirement that a copy of the warrant be filed where the warrant was issued for all search warrants.
No, right, we're moving on to the next section. I'm just saying this, so then, back to the Shenandoah example, I'm Delegate Gilbert's deputy now. If I'm just a Shenandoah deputy, I go to the local magistrate, get the search warrant, I have it in my hand, I want to fax it to the bank to get the records. And so, just trying to understand where the return is.
I think that's a question that I have for maybe the magistrate.
Yeah, well, Mr. Chair, and clearly you've recognized that the first portion that was of concern was dealing with the affidavit and the filing by the magistrate. This is the inventory after execution being filed by the officer, and counsel makes a good point. It does lack some clarity that where is it executed when it's stuck in the fax machine? Is it executed where it's placed in the fax machine by the officer, or is it being executed where it is being received by the business? And is that where it's executed? And then he needs to make the determination where to file his inventory.
So going back to old school paper, if it were executed by handing it to a guy at the front door, that is where it is executed. So far, so good? Okay. And that is where it is filed before we change everything?
That would be where the officer would file his inventory, correct.
Okay.
So using that logic, the statute would appear that the officer from Richmond who's executing it on someone in Virginia Beach would file the inventory in Virginia Beach.
Okay. Now, current law, what happens in Charlotte? The one that is coming out of Charlotte, same thing, but without electronic. The enterprising deputy gets in his car, or I don't know how you do this. How do you serve an out-of-state
you'd have to serve it on their registered agent within the state, which is what they have been doing is they serve the actual warrant. In this area, there's a Bank of America building has a place called the Corporation Service Company, which basically is the registered agent for tons of corporations. And so the officer will drive down to the Corporation Service Company, serve the registered agent with the warrant, and then fax the warrant to the legal department in another state for them to actually comply with it, because the records aren't actually housed here in Richmond. So that's currently what would happen. So right now, if we were current law, if this was the current law, without the electronic part, we would be filing the warrants in Richmond, because that's where it was executed, even though then they went and faxed it to Charlotte to get the actual documents.
Okay. So it actually is still intrastate.
It is intrastate because the deputies and police officers don't have any power to travel outside the state and serve search warrants.
All right, so everybody, we just have if we like this at all, when you decide if executed means where you hit the send button or where you hit the retrieve button. I mean, trying to be consistent, it sounds like it should be where it's retrieved. Okay. With that Virginia Beach versus Richmond example, it's Virginia Beach. Okay. Can you draft something to that effect? Okay.
And Mr. Chair, I will add for the first section dealing with the filing of the affidavits, it does state on the affidavit when we file a copy somewhere, but it's nowhere on the search warrant itself when we file a copy of the affidavit.
Okay. So, we haven't taken temperatures yet. Everybody in the audience, we love to tinker and work on bills, and we will do that for hours as you're already watching. And sometimes we will tinker on a bill that is not ever going to make it out of committee. We try to not do that by taking a temperature. So what I'd like to do, I'm about to do some more wordsmithing, is take a temperature whether this is something we kind of generally like or don't like. So if we are continuing to get the wording right, is this something that people are okay with? Okay, all right, that's fine. All right, so let me ask staff then, if you could go ahead, counsel. All right, so if I'm going to make a motion to ask you to include some language about that execution is where it is received. Okay. And then let me ask you this, that stuff at the bottom about return shall be made to circuit courts within 3 days, Saturday, Sundays, or each federal state holiday shall not be used to compute in a 3-day period. We have 1,400 periods in the code. As you know, we're terrified of putting it someplace and not someplace else. Is there a reason why we have to put it here and not the other 1,400 places?
I believe it's already in the return language earlier in the statute, Mr. Chairman.
I see it up above.
Mm-hmm. So I don't believe you need to add that in this language as well.
Well, except that if it's someplace up there and not down here, then I can see an argument being made that we better keep it. Okay. I want to take a motion, or I'll make a motion. Yes, Delia Watts.
This is one just technical detail. On line 97, the phrase or electronic means, I think needs to instead be the language that's on lines 22 and 23 by use of filing and security procedures as defined in the Uniform Electronic Transaction, that if you've got that language there, which is very specific about what electronic means, that should be the same language we use instead of the generic or electronic means on lines 97. So it's just it's technical.
Counsel.
Mr. Chairman, I think that the language in the earlier lines deals with the service or the transmission of affidavits, which can contain extremely sensitive information. That's why it has the security procedures. The lines in 93 through 105 are just talking about the actual warrant itself, which wouldn't have that.
And you don't have security issues when you're
well, warrants are public documents anyway. The affidavits can be sealed. The warrants are always going to be public documents.
All right, so I will move, and I'll entertain a second that we include the language about the location of execution. All right. All in favor, signify by saying aye. Aye. Opposed. Okay, so counsel, if you will prepare that. So Delegate Poga, what we'll do is we want to get this off the table today. He's going to work on this a little bit. If you could just sort of go back to the end of the line, by the time we get back to the front, council should have language that we need. Okay.
Okay. When would I come back?
I think he'll be able to do it in the next 20 minutes. Just grab a seat. We'll get back to you.
You'll let my office know.
I'd suggest you just stay. You're welcome to go up, but in 10 minutes we're going to call you.
Okay. I have a 4 o'clock.
No, that's why we want you here. here in case he has any questions for you. Okay. All right, bye temporarily. Delegate Farrell, you're up.
Yes, sir, Mr. Chairman, I believe council has something printed out for you, sir.
All right, so Mr. Cotter is distributing something for us.
Mr. Chairman, I think if I may summarize quickly what we didn't want to, after talking amongst the couple of us that were talking, I don't think anyone wants to go down the road of, well, what does it really say about circuit courts and all that? We may need to clean that up later. So what we did in this substitute is merely also allow the option for district courts to do it if it's within the jurisdiction as well. So
Okay. Anyway, this is bringing back House Bill 1513 that we worked on a couple hours ago.
Stand out of Albo's hair.
Anybody have any questions for the patron? In meaning of the public, have any comment on what we're about to actually pass? Okay. What is our pleasure on the bill? Okay, motion's been made, report is amended. Is there a second? All in favor signify by saying aye. Aye. Opposed? Excellent.
Mr. Chairman, thank you, sir.
Okay. Delegate Ranson, 1844. And then LaPasa.
Thank you, Mr. Chairman. House Bill 1844 seeks to amend the code relating to the responsibilities of the Executive Secretary of the Supreme Court. You'll see that I've added language to clarify the duties that include overseeing the online courts information system that is searchable by defendant's name across all localities and across all courts, and this would be free to the public. This legislation also expands the information system to include all the adult cases of the JDNR courts. I've included these cases so that repeat offenders and adult convictions of family and domestic violence are searchable across the state, and it's free by anyone.
Okay.
I know you all are probably wondering why I'm bringing this legislation, because I'm usually not before this committee. I was approached over the summer by a woman, and she had been beaten horribly by a boyfriend, and she said, Margaret, there's no way. I became involved in this relationship, and I went to the sheriff's department, and I wanted to find a way to learn a little more about this man, and the more I became involved with him, he would not leave me alone. And it got to the point where he was physically abusing her. He did get a protective order. She got a protective order out on him, but she wanted to see if he had been doing this to other women in other states or even in her own state. Ultimately, with the protective order, the sheriff came to her house and said, listen, I'm going to stay with you until he breaks this protective order, because I can assure you he will come here and he's going to abuse you again. And he did come. He finally left the state, went to Florida, and was ultimately shot and killed by the boyfriend of someone else that he began abusing. I called the Commonwealth's attorney where this happened, and he said, I remember this case. It was violent, and I said, well, what about a registry? And he said, look, we can't put any more on the state police. We can't develop a registry, but if you go onto the court's information system, there's a way that we could do this. He said, if you go on there, it's hard to understand, it's hard to track people, and we need to figure out a way to search people by name across the state, and there's no reason why we could not include the adult cases of the JDNR system to protect families, to protect children, to protect women and men that have been abused by domestic violence. So that's why I'm bringing this.
Does anybody have any questions for the patron? Okay, so I want to ask counsel. So those of us who practice in this field use this 10 times a day, every day. It is not searchable except county by county, and it's not searchable for adult domestic cases at all. Does everybody agree? That's right. Current law. Okay, all right.
Mr. Chair, on that.
Delegate Gilbert.
So we're dealing effectively with two concepts as far as substantive changes, as far as I can tell. And I thought the gentlewoman was putting this in as two separate bills, so I apologize if I had any part to play in that confusion. But the first issue is the statewide searchable system, or that's one issue anyway.
Yes.
Right, and then the other one is making it so that the Supreme Court puts the adult, juvenile, and domestic cases online.
Yes.
Which they don't currently do, which we just established, I think, right? So, but this is the only vehicle you have for those two concepts, correct? Okay. Okay, thank you.
Mr. Chairman,
Yes, sir.
my understanding and experience with this has been that there are at least two jurisdictions that currently do not participate in the court information system. It's Fairfax and someone else, and someone else from Northern Virginia might be able to correct me. This would not mandate that they become a part of the court information system. So only those that have voluntarily participated will be part of this. Is that correct?
No.
Think I'm putting a
I mean,
mandate.
that they have one. It doesn't say that it has to be that one.
Fairfax participates in their own separate system and has for as long as they've had a computerized system.
Right. This bill doesn't make them participate in the Supreme Court system, but it does make them have an online system.
Would there have to be a linkage that Fairfax would have to somehow link into this to
In order to be
participate?
statewide searchable, yeah. So I'm stuck on the other concepts. That's the statewide, absolutely, yeah.
So that could be a, okay, thank you.
No, you're right.
Yeah, Mr. Chairman.
Yes.
My reading of the bill is that it would require the Supreme Court to somehow pick up those Fairfax cases. No?
All right, so everybody, somebody from, if Alba were here, could say this. I think this, can somebody help me? I think they're both. I just pulled up the Fairfax cases in the online general district court system.
The circuit court does not. I'm on the circuit court CI.
I'll bet that's right. Okay. But not the, you agree the district court is covered?
District court is,
Okay.
but circuit court is not.
That's fine.
And it's also Alexandria and Fairfax Circuit, they don't participate. Believe their court information systems were not compatible when the Supreme Court updated their system.
Delegate Gilbert, I'm sorry, did we cut you off?
Yeah, no. If you want to take the public.
I will. All right, so any members of the public like to be heard on this issue?
Thank you, Mr. Chairman, members of the subcommittee. My name is Megan Ryan. I'm with the Virginia Coalition for Open Government, speaking to the first part of that bill, the statewide system. The current system is right now pretty cumbersome and unnecessarily so. I mean, there's clearly not an objection to the public having access to the information about these individual people in each individual jurisdiction, since there is the ability to look them up one by one. But citizens, reporters, and employers would benefit from a comprehensive search function, in our opinion. A citizen could be checking a home health worker who might be coming to care for one's parent. A reporter might be needing to do some research on a suspect in a local homicide. An employer may be wanting to hire someone who would have responsibility over money. So it's not a difficult technological change either. 2 years ago at the Coalition's annual conference, after hearing from reporters who were having some problems with the system, a civic hacker, a coder, whatever you want to call him, built a rudimentary website that accomplished what Delegate Ranson's bill does in about, he built it in about 3 hours. That site is called the Virginia Circuit Court Search.com, and it does do what this bill suggests, but we believe that it is more appropriate for the OES to provide this service to the public. Thank you.
What's it called again?
VA Circuit Court Search.com.
I want to see if it's easier to use than the Supreme Court system.
Mr. Chairman, Christy Wright, Office of the Executive Secretary, Supreme Court.
We do not have a position on this bill. There will be a fiscal impact in order to go in and change the systems that would be required to do this. Whoever had created that system has a lot fewer concerns about security and the significant hits that we will have to, that the system will be able to handle. Within a 1 month period, there were over 65 million hits on the systems. And you also have to remember that the systems are close to real time, and that the clerks are also entering the data into the case management systems that they use to process these cases. And that combined then with what we anticipate being added use of the system, if it is statewide, would be significant, and there would be upgrades needed to the hardware to maintain security and usability for the clerks and the public. The other thing I want to add, just to clarify, I do agree with Delegate Mullen that Fairfax and Alexandria are the 2 circuit courts that are not on our system. The way I read this, I don't see that would require that they be on the system. I think that's a separate statutory provision that allows circuit court clerks to have their own systems. And I think there is a possibility, depending on the various thoughts of the clerks, whether or not they want their information on a statewide search. We just recently had Henrico and Chesterfield come on to the online case information system. So I think it's possible that others could decide that they don't want it on and request that their records not be available. And then to a comment that was also made about criminal background searches and employers wanting to know, I would really caution, these records are not intended to be used for criminal history. That was really within the realm of the Virginia State Police, and by statute, they are the people that is the entity that should be providing criminal background checks.
Man, wait, don't leave. On the last thing, maybe I missed it. I heard it while trying to read something on the screen. Are you suggesting that this should not be these are court records?
Correct.
They're publicly available if you can go through the firewall and look them up county by county. I mean, is this not, simply reorganizing that data? It's all in there. I mean, obviously I can find it with 3 extra clicks if I know where to look.
You can, but it's about how the systems are constructed on the back end and the databases and how they are constructed. And I don't have somebody here to go into all the technology of it, except to reiterate, I guess, or to convey what they told me. But it's a part of the mainframe and the databases. These are 3 very different systems that we're talking about. And some of them, we're talking about hundreds of thousands of records per locality and millions of records across the state. And if you have 1 million cases or so many cases filed per year in the district courts, and some of those are 10 years, 20 years old. In the circuit courts, you have records at least 20 years and some even older than that are maintained.
Mr. Chairman.
Delegate Gilbert.
I'm going to switch topics. Could you address the reason why the adult, juvenile, and domestic cases are not available online in any jurisdiction?
I think some of it was as far as prioritization over the years about getting out the circuit and then the general district. At this point, none of the juvenile records are, and I think there had been some concern about the possibility, it was kind of like a lesser priority, concern about letting out something that was confidential and that sort of thing. And then also it's a resource issue. Technology is what we are using, we understand that, we need to go there. But there are older systems, they need to be updated. We're working to get the general district case management systems, not what you see, but what the clerks are using off of the old green screen.
Yeah.
So we're working to get that into job, and I know the clerks are really wanting us to get that done.
That's a huge problem. I mean, the antiquated software they're still using, it's unbelievable. So do you all, just sort of as an aside, but also on this topic, do you all have any kind of estimate of how much it would cost to get all of those systems converted to an up-to-date software system and up to speed and online and ready to go? Like how many millions of dollars that would cost?
Well, the general district update to the Java is underway, and we expect that to be done.
So is that funded already?
Yes.
Okay.
As far as this estimate that I've provided Delegate Ranson, it is 1.28 million, I believe. And a significant portion of that is a mainframe upgrade to handle that. You know, the other thing is that with each time, you know, that we've had different projects that come up. We've had the electronic transfer from general district courts to circuit courts of appeals. We've had, you know, through the General Assembly, DMV wanting to accept online payments. So all these different projects that come up and come through actually takes us steps back, because that places that priority above something that we have had to do with limited resources. It's a matter of putting a project on hold and then moving forward with something that we're obligated to do by a July 1 deadline. So we recognize that and we're working toward it. It's a resource issue.
All right, anybody else, ma'am? Yes.
Yes.
Tell us your name and tell us your thoughts on the bill.
My name is Betsy Edwards, and I'm the Executive Director of the Virginia Press Association. We're in support of a statewide database, obviously, for the Office of Executive Secretary, the court records. It's incredibly onerous, obviously, to look at these court by court, and we know our reporters, our editors, and the public in general would like to have the ability to see this on a statewide basis. So we're in support of it. Thank you.
Posse, are you just adjusting, or are you getting ready to testify?
No, just adjusting.
That's fine. That's okay. All right. Anyone else in the public like to? Anyone else in the public like to testify on this bill? Oh, Ms. Hall. Yes, ma'am.
I thought it was low enough. Good afternoon, Christine Hall, members of the committee. Thank you. We don't have an official position on this bill. We had some of the concerns that others have raised here today. We recognize that this is already public information, and certainly if we were going to go down this route, we recognize and respect the resources that it would take the Office of the Executive Secretary to look at this, but certainly think that is the appropriate body to ensure that as the information is made available online, that critical attention is given to the sensitive nature of cases in the Juvenile and Domestic Relations Court, and ensuring that the cases that are intended to be public information are public, and those are not, that are kept not, and that we're just aware of the sensitive nature of such information being available at large to the public.
Yes, sir. Mr. Doucette.
Mr. Chairman, Mike Doucette, Commonwealth Attorney for the City of Lynchburg. On behalf of the Virginia Association of Commonwealth Attorneys, and we do support the bill. We do believe that the bill is victim friendly, but I do have a couple of concerns about the actual drafting. And certainly Delegate Gilbert touched on some of these with his questions as far as adult cases in the juvenile system. We're assuming, I don't think it's in the language, we're assuming that we're going to capture all cases going back however long it takes to go back. But there's nothing in that language that necessarily says that you have to go back. You could certainly read this existing language to say that it's only current cases that are currently in the courts. The other thing, of course, is how much data is going to be out there. Again, we're assuming that all the data that's within the court system is going to be on this particular online case information system. But right now, all that's required is the defendant's name and the locality. There's nothing else that's required in there, and it could be interpreted to say, okay, that's where it's limited to be. And I don't think that's the intent, and I certainly don't think that that's what we're assuming that this bill is trying to do. I do think that Ms. Hall has touched on some issues that we do need to be victim sensitive as far as previous cases and identifying victims in certain types of cases. So I think there's still some work that needs to be done on this language, while we do think the idea is a good one.
We're the ones who do the work, so what would you like, what changes are you suggesting? This is the place where this will get done.
Of course, one of the issues that's been raised is how much work is this going to put on OES, and I think that is a valid question. I started off chiseling in stone, so I don't know computers, and so I would suggest that maybe there's a time limit that you want to go back and say cases from the last 10 years, whatever it might be. I don't know how long their database goes back, how easy it is to convert to this new online case management system. I'm better in this situation asking questions than coming up with answers certainly when it comes to
You
online
should sit on this
information.
side of the dais then. Ma'am, so, talking out loud, if we said we just want the data that's already there to be available in a different way, and I'm not much more savvy than Mike is on the computer, but I'm not saying that they need to suddenly start scanning in files from 1830. It's just, right now, I can go in and look at, for the courts that are already online, the data that's already online. Now, we want to have a bunch of caveats about the limitations, but
that
now
is
listen,
how,
I mean, I know some courts go back further than others, some courts, what's the,
I think when we did the fiscal impact, our expectation is it would be consistent with what's currently out there. Nothing, that would not change. And so if, in what would occur on the adult JNDR records, it would be those records that are currently within the case management system. So, for instance, if a record is to be held 10 years and the retention period is 10 years, and then after that the clerks are to destroy it, the paper records are destroyed, and the record online is then destroyed as well. And so it would be consistent. And so we would pick up in the JNDR adult those cases that were already in the JNDR case management system for the adult records.
Mr. Doucette is correct, that's not what this says. I mean, I think this could be, what's concerned would be that some of this language gets read that you didn't have to literally be hiring people in Greene County to go back to 1830 to be putting the stuff that's not there already. Is that fair? Okay. Does the council have any thoughtful ideas on how to just say, open up what's already there? Margaret, do you understand what we're saying? You came into this thinking that stuff is sitting there, let's open it up. What they're saying is not everything is online, which is true. And you got these two courts which are not online at all, they're on their own separate system.
But the files, they have the files, correct?
Our office does not have Fairfax Circuit Court's case files. They're online case. They're the records that they maintain in their case management systems, nor do we have it for Alexandria.
But everybody else would have.
Correct.
Delegate Albo.
Say of all case files currently preserved in electronic format, that way you wouldn't have to have anybody go and convert paper to electric.
The one problem could be those courts that are scanning all of their records. So they would then have their paper records in electronic format, but that doesn't necessarily mean they're in the electronic case management system, which is what we're talking about.
Currently in the electronic case management system.
They're saying they shall maintain an online case information system of those files currently in the case. I mean, that's a
Currently in their case, in their private case management information system.
let's take another. Let's do a temperature real quick. Is this something we want to do? I do.
Yeah.
Yeah. Okay, that's fine. Just do the temperature. That's fine.
Mr. Chairman.
Yes, ma'am.
I don't want to talk myself into a hole here, but as I started digging into this a little bit, they've been receiving nearly $11 million since 2000. I mean, I don't understand why we're not getting more things done. I'm not an IT person. I'm certainly not involved in the courts, but I come up here to represent people that pay a lot of money.
You identified
in
a
taxes.
problem with this. We're saying this solution doesn't get, as you put it together, doesn't get you where we need to go. In other words, this is not ready to be voted out of here. Well, we usually would have to work on it with somebody. We'd try to do that today. I don't think so either. All right. So the issues that are obviously right in front of us would be, right now, this would apparently cover every record since the dawn of time. And it doesn't say what you want to do with Alexandria and Fairfax. It's your bill. You could say they will, with all their IT people, figure out ways to bring those in. That will surely be a harder lift than just finding some way to reorganize the data that's already there. We don't think we can do this today. Why don't back to us at our next meeting. Is that, Sue? Okay. All right, so I'll entertain a motion to go by for the day. Okay. All in favor, signify by saying aye. Aye. Opposed? All right, you got your, okay. All right, we've got the posse, then Poggy, are you ready? Brenda, are you ready?
She can't hear me.
That's right. That's it.
You ready to call next? Yeah, she's ready.
What do we have here? You'll just figure it out and get back to us. All right. House Bill 1647, Lepasi.
Thank you, Mr. Chairman. All right, this fine piece of legislation before you was brought to me by a friend of mine who's in the Chesterfield Board of Supervisors. And he also practices law. Here's the situation. And this is, I never knew this. You're in circuit court, you got a case, you plead guilty pursuant to an agreement with the Commonwealth, then you can waive your pre-sentence report with the concurrence of the Commonwealth's attorney and the defendant. The judge can waive the pre-sentence report. If you, let's say I've got one of these fine Commonwealth's attorneys, like the one from Roanoke over here, and I got a case with him, and I want to plead guilty, but we haven't worked out the agreement yet, but he's ready to do the sentencing. He's got the guidelines prepared. My client pled guilty. He's got the guidelines prepared. He's ready to go. I'm ready to go. We just want to be done with the sentencing and move on down the road and see that justice has been done. Under the law as it currently is, the judge has to order a pre-sentence report, which is a lot of work and a lot of money to produce a pre-sentence report. I didn't know this. The other thing, sometimes we have what's called in vernacular, practitioners vernacular, I'm sure Delegate Alba would know this one, it's called a slow guilty plea, which is a judge trial, okay? So we plead not guilty to the judge. He knows what's likely going to be happening. The fine prosecutor from Roanoke knows what's likely to be happening. The defense attorney knows what's likely to be happening, and that is that our client will likely be found guilty upon the presentation of the evidence. But he knows what the sentence should be. I have a pretty good idea what the sentence should be. We don't need a pre-sentence report. He doesn't want it. I don't want it. We just want to be done. But the way the law is written now, those facts, the judge would have to order a pre-sentence report, which is not efficient. So what this bill would do is, it would say is, if you plead not guilty, or if you plead guilty without a agreement, that the defendant and I need you to add in line 21, Mr. Gilbert, anticipating what you're going to say. In line 21, I need you to add, after it says waived by the defendant, I needed to say, and the attorney for the Commonwealth. Line 21.
This is how you would like your bill?
Yes.
Okay. So Delegate Gilbert
So moved.
has moved, and is there a second? To add and the attorney for the Commonwealth in line 21 between defendant and the comma. All in favor signify by saying aye. Aye. Opposed?
Thank you. So with that, I think I've hopefully adequately explained it. I think it has the support of the Commonwealth Attorneys Association now with that amendment. And this is for like the